disproportionately, when we're talking about essential workers, we're talking about women of color.
The amount of stress that these pandemics have put on women healthcare workers is kind of unfathomable.
And so this intersection of race and gender, intersectionality, as Kimberly Crenshaw calls it, results in a disproportionate impact on women, particularly women of color and Black women within the criminal legal system. My name is Alexis Hoag, and I'm a practitioner in residence at Columbia University within the Eric Holder Initiative for Civil and Political Rights. And I came to Columbia after spending over a decade as a criminal defense attorney and also engaged in civil rights litigation. I started my career with the federal government representing individuals who had been sentenced to death and were seeking relief in federal court. And then I transitioned to the NAACP Legal Defense and Educational Fund, known as LDF, to advance and protect the rights of Black Americans to bring about a more inclusive society for everyone. At Columbia, it's been a real privilege and an honor to work alongside students, both within the college and the law school. And it's at the law school where I serve primarily as a lecturer in law, teaching courses in abolition of a carceral state, and then in training students in capital post-conviction defense. Today I'll be speaking about policing Black bodies, race, gender, and the criminal legal system. And I use the term criminal legal system rather than criminal justice system because it is not yet just. And I wanted to carve out the particular impact the criminal legal system has on Black people and also on women. And given the systemic racism in this nation, which I argue is a direct holdover from slavery, there is a very particular experience of Black people, of brown people within the criminal legal system because of the racial hierarchy that was instituted during slavery. And you see the remnants of that, the holdover of that in the policies within the criminal legal system today. And then, given the unique experience of women in this country, who also did not have equal rights and citizenship at the country's founding, that still persists today. And so this intersection of race and gender, intersectionality, as Kimberly Crenshaw calls it, results in a disproportionate impact on women, particularly women of color and Black women within the criminal legal system. The way that the criminal legal system operates today, one cannot divorce it from the early experience of the American colonies. So beginning in 1619, when those of African descent were brought to the shores of the American colonies as enslaved people, the early colonial legislatures, the early colonial governors actually instituted laws that designated and distinguished conduct based on race. For example, in some of the early colonies in Louisiana, in Georgia, certain criminal conduct was only considered a crime if a Black enslaved person did it. And so if a Black person were to strike their white master and draw blood, that was an offense that was punishable by death. Whereas if a white person struck a Black person, that was not necessarily a criminal offense. And those early laws, the only means of redress that a Black victim of crime had was that their owner would be reimbursed financially for a diminishment of property or a loss in property. So the very early laws that we had before the country became a nation actually distinguished based on race. Looking at the experience of enslaved women, Black women, crimes against them were not necessarily considered crimes. The rape of a Black woman was not considered a crime. And this you see extended into the 20th century. The Legal Defense Fund, the NAACP, was conducting research on the death penalty. And they looked at the state of Arkansas, and they looked at who was being sentenced to death for the crime of rape. Our country outlawed capital punishment for the crime of rape in the early 1970s, but during this period, one could still be sentenced to death for rape. And the Legal Defense Fund looked at 4 categories in Arkansas. They looked at the rape of Black women, the rape of white women, and the conduct performed by white men. So white men raping white women, Black men accused of raping Black women, Black men accused of raping white women. However, there was no indictment ever for a white man raping a black woman. This is research conducted in the mid 20th century. And so you see this holdover from the colonial period, where such conduct was never considered criminal. And that extended into the 20th century. Other ways in which our early criminal legal system disproportionately impacted Black people, enslaved people at that time, was that it was a means of control and monitoring the movement of Black bodies. And so after enslaved people were emancipated in the 1860s, you had the resurgence, the emergence rather, of the Black codes. And so the criminal legal system replaced the institution of slavery as a means to control and monitor the movement of Black people. And so there were laws passed that were neutral on their face about trespass, vagrancy, and those were disproportionately enforced upon Black people to virtually re-enslave them. And so what happened during the Reconstruction period following the Civil War is that you had this expansion and recognition of Black rights and citizenship. Prior to the 1860s, Black people were not considered citizens. The U.S. Supreme Court decision in 1857, Sanford versus Dred Scott, actually explicitly explained that the Constitution did not envision Black people to be citizens. Dred Scott was suing for the freedom of his spouse and his children. And the U.S. Supreme Court said, that's not a lawsuit you can file as a Black person because you are not actually recognized as a citizen. The Constitution did not actually recognize Black people of African descent as citizens. So just a few short years later, we have the Emancipation Proclamation. We have the passage of the 13th Amendment, which prohibited the enslavement of Black people. We have the passage of the 14th Amendment, which is meant to extend the equal protection of the laws to Black people. I mentioned before that there was no means of redress for Black people who are victims of crime. The 14th Amendment was passed to extend the protection of the laws to Black people. And then the 15th Amendment, which extended the right to vote. So we had this expansion of rights, this recognition of citizenship during this window of time, 1860s to about the late 1870s. And then that was effectively stripped away through intimidation, violence, and racial terrorism directed at Black people. So one cannot divorce early American laws, both from the colonial period and during this period of emancipation and Reconstruction, from the way that the criminal legal system operates today. And I look to Bryan Stevenson and his work at the Equal Justice Initiative that's really drawn this unbroken thread between the period of enslavement into the period of the late 1800s, 1900s, and today's criminal legal system. And also the work of Sherilyn Ifill and the Legal Defense Fund that again draws this link between the racial hierarchy of this institute in this country and the way the criminal legal system operates today. And so we have this period of mass incarceration in the 1970s, the beginning of it. And so we saw the prison population in the United States explode from approximately 200,000 to over 2.2 million today. And although there was a rapid increase, a rapid explosion of the prison population, women in particular felt that most heavily. And their rate of incarceration over that same period is twice as high as the incarceration rate of men. So the period of mass incarceration, which started in the 1970s, was really a reflection of changing legislation and criminal laws. And you actually had leadership within the administration. President Nixon and his advisors specifically targeted people of color. And there was this increase attention to drugs and drug use and drug selling. And even though rates of drug use were virtually equal among white and Black and brown people, there was a disproportionate targeting of Black and brown people. And that was really to sort of clear house of what was going on. There was a lot of public protest in the late 1960s, a demand from Black people to be treated as equal citizens. So you had a federal administration that was hostile to those pleas, hostile to those demonstrations, hostile to those demands, and then created a criminal legal system to then target low-income Black and brown people and to literally warehouse and ship them into prisons. And so you had this massive explosion. The impact was felt so severely and with particularity on women and women of color. So the United States has 5% of the world's population, but yet accounts for 30% of the women who are incarcerated across the world. And so the explosion of mass incarceration is really felt with particularity on women in this country. And what's unique about the experience of women who have been incarcerated is that 80% of them are mothers. Over 60% of them have children under the age of 18. And so when you look at this exploding population of women who are incarcerated, it has a devastating effect on families and on young children. And what we know about the impact of incarcerated parents is that it can increase the incarceration rate of children. And it produces adverse childhood experiences, additional trauma for the subsequent generation of children, of this massive population of women who we are incarcerating. And then within those demographics, the incarceration rate of women of color is higher than of white women. And so Black women are actually incarcerated at a rate twice as high as white women. And it's not necessarily even in state to state. You have some states such as Oklahoma, which is the highest rate of incarceration of women. What is unique about the women who are incarcerated, particularly women of color, is that they're targeted much more than men and much more than white women in particular for drug crimes and property crimes. That outcome reveals the underlying structural racism that exists in America. People of color are much more likely, particularly in urban settings, to live in hyper-segregated, under-resourced communities that lack access to quality healthcare, that lack access to healthy food, to living wage jobs. So much of crime can be explained, particularly nonviolent crime, can be explained by a lack of access to basic needs. And so when looking at the fact that women, particularly women of color, particularly Black women, are prosecuted for property crimes and drug crimes, so much of that could be explained by a lack of access to basic needs, safe housing, quality healthcare, healthy food, and childcare. And the fact that we have a gender pay gap so that women are earning less than men. I believe it's around 81 cents on the dollar for women in general, and then 75 cents on the dollar for women of color. And so the lack of opportunity to actually earn a living wage while also securing childcare is something that is felt uniquely by women and with particularity on women of color. And so when looking at the explosion of the prison population over the last 40 years, the rate of women's incarceration, I believe since 1980, has increased approximately 700%. That is alarming. Those are rates that we should all be concerned about. And again, it's because of the unique experience of both sexism and racism, that intersectional experience of women of color, particularly Black women. Simultaneous with the mass incarceration and the increased rate of women being charged, prosecuted, and sentenced to prison, you have this parallel track of the school to prison pipeline. And there's a unique experience of girls of color, particularly Black girls, in schools. During this period of increased police sort of presence in under-resourced communities, you also have an increased police presence in under-resourced schools. And under-resourced public schools tend to have higher populations of Black and brown students. And there's been some fantastic social science research on the experience of Black children in schools and the over-disciplining of Black children. And the Yale Child Study Center actually looked at teacher eye tracking of students as early as preschool. And they found that teachers tracked Black students much more than white students, and actually Black boys much more than any other population. And so with tracking student behavior, there was an expectation that Black children were disruptive and needed to be punished. And what I found in my work at the Legal Defense Fund, in working with school districts that were under federal court monitoring, decades after being found to not abide by Brown versus Board of Education to desegregate their school system, they're still under court monitoring in the 21st century. But looking at what was happening in those public schools, was that there was an over-disciplining of Black students. And when I say over-disciplining, it was for out-of-school suspension, out-of-school expulsion, referral to the criminal justice system, and for longer periods of time. And what was so distinct about the way that Black children were being disciplined in school is that it was for behavior that was subjective. So a student who brought a weapon to school, that is objective. You either bring the weapon or you don't bring the weapon. And so there really wasn't a racial disparity in who was being disciplined for those types of offenses. But it was the subjective conduct, such as speaking out in class, being disruptive, acting aggressively, sort of gray area. And so that study from the Yale Child Studies Center with eye tracking, this expectation that Black students are the ones that are being disruptive and have behavioral issues, really played out in how schools were actually pushing students out of school with punishment. There was a fantastic book by Monique Morris called Push Out about the experience of Black girls in particular. The Legal Defense Fund, just a few years ago, published a report on the experience of Black girls in Baltimore. Black girl population is about 30% of young people in the state of Maryland. However, Black girls in Maryland that are placed in the Department of Juvenile Services, it's approximately 60%, 65%. And looking at my own work as a law student some 15 years ago, working with the Legal Aid Society that represented young people that were processed through the family court system as an alternative to the criminal legal system. And what I found when I was working in Brooklyn was that so many children of color, particularly girls, were being placed in juvenile correctional facilities because they lacked robust after-school activities, or they were experiencing trauma, abuse at home. There's a mechanism in the court system, and in New York it's referred to as PINS, person in need of supervision. And something similar exists in many states in their juvenile justice system. And so a parent or a guardian comes to the court and says, I can't control my child. They're out after curfew. I don't know where they are at night. Court system, please give me assistance. And our court system is actually ill-equipped to deal with children who are in need of supervision. What that child needs often is robust after-school programming, our social services, potentially counseling, tutoring, activities to keep them engaged in. Instead, what our juvenile justice system does is place them essentially in a child incarceration center. And so when you had parents from under-resourced communities bringing their child to court as a person in need of supervision, or a school resource officer, essentially a school police officer, was bringing a child to the court system because of truancy, that child was then placed in incarceration. So what you find with girls, particularly Black girls, is that they're placed in those facilities, and they're placed for longer in those facilities because they lack resources at home and their communities to keep them engaged and to keep them at home. And because we have a higher percentage of Black and brown children that are low income and that don't necessarily have resources, private money to keep them at home, to have counseling at home, they're then pushed out and placed into the juvenile justice system. And what we know through research and data collection is that placement in the juvenile justice system increases your rate of incarceration in the criminal legal system as an adult. And so you do have this direct pathway from schools into the adult criminal legal system. And so to have girls, particularly Black girls, being pushed out of school as early as elementary school, placed into juvenile correctional facilities, they have a higher percentage, a higher chance of them being in the adult criminal justice system. And what we know about through social science research, those that are placed in the juvenile justice system, those that are placed in the criminal legal system, they have overwhelmingly experienced trauma, abuse, and sexual abuse in particular. And so the solution for someone that has experienced trauma should not be incarceration. It should be wraparound therapeutic services, robust counseling services. And what we found is that in this country, we have outsourced our social service needs to law enforcement. And so when you have law enforcement swooping in to address issues of trauma, mental health crisis, someone who is in need and in crisis, you have the criminal justice system coming in to address those needs, as opposed to social service agencies, social workers, robust community services. So what you find in schools for students of color, particularly Black girls, there's this presumption of criminality, presumption of dangerousness. And social science research shows that people actually perceive Black children to be older, chronologically older than they are, and that Black girls need less nurturing or have a higher tolerance for pain. And so much of those perceptions and assumptions, I argue, are a direct holdover from slavery. And we see that play out in the criminal legal system and law enforcement engagement with people of color. There's a presumption of criminality, a presumption of dangerousness. And so when looking at who the police target for stopping and searching, for frisking, in terms of the unequal sort of physical treatment of suspects who are Black and brown, lethal use of force, It all stems from this presumption of criminality and the presumption of dangerousness. And that is a direct holdover from the racial hierarchy that was instituted during the period of enslavement. And so the experience of Black children in school and those eye tracking studies from the Yale Child Studies Center is that there is a presumption that a Black child is engaged in misconduct, is looked at criminally, and is looked at as dangerous. Jennifer Eberhard is this psychologist from Stanford, and she produced a study within the last about 5 to 8 years called Looking Deathworthy. And she looked at juries who sentenced defendants to death. And she found through her research that defendants who looked more phenotypically Black, with darker skin, thicker lips, a broader nose, were more likely to be sentenced to death. And so we see that play out in the adult criminal legal system and also in the juvenile justice system. And that's why you have these stories of children, Black children, that are being handcuffed and removed from school as early as elementary school because their conduct is seen as being disruptive and worthy of discipline, whereas a white child may engage in this sort of behavior and is looked at as merely being a child because there is not that presumption of criminality assigned to white children. And we have the social science research to show that. So George Floyd's murder at the hands of law enforcement really galvanized this country and really the world to assert the very urgent message that Black lives matter. And what we know from early American colonial history, our period of enslavement, is that Black lives did not matter. There wasn't a means of redress for Black victims of crime. And so here we are today in 2020, that Black and brown individuals at the hands of law enforcement are experiencing violence because of this presumption of dangerousness and criminality. But what is missing from this conversation, what is often missing from many of these mass demonstrations, the outrage is outrage at the fact that Black women, trans Black women, gender non-conforming Black people are disproportionately impacted by police violence as well. And the fact that just last year, almost 30 trans people, trans women were murdered at the hands of law enforcement. And over 90% of them were Black trans women. So what's so important to think about in terms of this recent mass demonstrations for Black Lives Matters in the wake of George Floyd's death is that it's not just Black men that have these lethal encounters with law enforcement because of this presumption of dangerousness and criminality. It's also Black women. And we know the name Sandra Bland. We know the name Breonna Taylor, but yet the law enforcement officials that are responsible for their murders have not been criminally indicted. We're still waiting on that. Particularly with Breonna Taylor, only one of the officers involved in her lethal shooting has been fired. The rest are still technically on the job receiving their pay. And Kimberly Crenshaw, my colleague at Columbia Law School, who's also on faculty at UCLA Law, started a campaign, an organization, a movement called Say Her Name to remind the public, to give voice to the unique experiences of Black and brown women that die as a result of engagement with law enforcement. And so much of what happens to Black women that die at the hands of law enforcement isn't necessarily the dynamic that's going on with Black and brown men. We haven't formed a framework to really discuss what is going on there. And so in some instances, it has to do with a mental health crisis. The fact that we call the police and have them attempt to address a situation which they're actually very ill-equipped to do. We should not have situations in which we call law enforcement for a mental health check, and the result is someone's death, a Black woman's death. Again, this has so much to do with having a lack of resources, under-resourced neighborhoods and communities, and to call police in to somehow solve these problems. Clearly, they're ill-equipped to do. So what's been interesting about the Black Lives Matter movement is really its transformation from something seen as fringe and radical when it was first started in 2013 and 14 in the wake of George Zimmerman's acquittal for Trayvon Martin's murder and Mike Brown's murder at the hands of law enforcement in Ferguson, Missouri, is the public perception of BLM today in 2020 in the wake of George Floyd's murder. And I argue what really served as the catalyst for that change is the insertion of COVID-19, is the extreme devastation of viewing a man being executed over a period of almost 9 minutes on film. And when I mention COVID-19, the fact that Black and brown people were disproportionately impacted in terms of infections and with death it really laid bare the systemic inequalities that have long existed in our country. And so it wasn't that Black and brown people were more susceptible to the disease in general. It was that Black and brown people were more vulnerable to infection because of systemic racism, because of hyper-segregation in urban communities, the inability to socially distance, and lack of access to quality health care, so that then Black and brown people had pre-existing health conditions because of systemic racism, because of systemic inequality, that made them more vulnerable to contracting COVID-19. And so really it laid bare what we've long sort of felt and known about the very institutions in this country. And the fact too that you had almost 40 million people unemployed. The time of George Floyd's murder, we had all been virtually cooped up, particularly in New York City, for about 10, 11 weeks. And that we were all sort of captive to our computers and cell phones in that quick dissemination of the video. And Derek Chauvin, the police officer, who was a metaphorical knee to the neck of Black America. And to hear a grown man who's not resisting arrest being held down with his face pressed to the pavement for almost 9 minutes, pleading for his dead mother. Everyone who saw that video was appropriately disturbed. And so in a way that BLM was seen as fringe in 2013, 2014. Today in 2020, you look at the images, the videos of the mass demonstrations, you see thousands of white people in the street alongside Black people, holding signs, chanting Black Lives Matter. And it's not just in the United States, it's abroad. It's in Germany, it's in Asia, it's in South America, all engaged in that awareness and recognition that Black lives matter. What's really been revealed in the mass demonstrations in the wake of George Floyd's murder is that the policing of Black bodies in this country is not sustainable. It has proved lethal to Black and brown people. And the fact that police officers, even when you ban certain chokeholds, even when you ban certain restraints, the fact that police officers can use legally lethal force against a suspect when the police officer feels that their life is in danger means that there will be lethal interactions for Black and brown people because of that presumption of dangerousness, the presumption of criminality when law enforcement officials engage with Black and brown individuals. Again, that is a direct holdover from slavery. And so the type of reform measures that must happen can't be these slight cosmetic reforms, what we've seen in the past. That police need to engage in bias training, that a police department needs to ban a certain neck restraint. In 2014, when the NYPD killed Eric Garner with the chokehold, chokeholds were technically banned in New York since the 1990s. But yet the officers there argued that they believed their life was in danger, which those of us that have seen that video know that wasn't the case. Eric Garner was charged with selling loosies. That's not an offense that should be met with lethal violence. The fact that George Floyd was suspected of tendering a $20 bill, counterfeit $20 bill, that should not be an offense that's met with lethal force. And so what needs to happen with our police departments, what needs to happen with law enforcement, cannot be fixed with a narrowly focused reform measure over police tactics. It has to do with the way that police view and engage with Black and brown people. And that's an issue that's much larger than just law enforcement. That's an issue that requires America to reckon with the fact that we instituted slavery for over 200 years and to come away with some sort of reconciliation for the denial of basic humanity to Black and brown people for as long as we did, because we still see that in the criminal legal system today. We still see that in the way that law enforcement engages with Black and brown communities. And so certain measures that would help during this period of necessary reckoning and reconciliation is that there must be increased accountability for law enforcement who engages in misconduct and lethal violence when they interact with Black and brown individuals. And so right now, there is an affirmative defense that an officer can raise, any government official really, but a law enforcement official can raise, called qualified immunity. So when an individual who has been wronged, whose constitutional rights have been violated because of police misconduct, seeks civil redress against that law enforcement official. The law enforcement official can raise qualified immunity, which then serves as a shield and prevents any sort of accountability or liability for that misconduct. And what's so fascinating about that civil means of redress that individuals seek from police officers, that statute, it's called 1983, is a direct sort of holdover from the Ku Klux Klan Act of 1871. And Congress passed that act to allow Black victims of crime to seek redress when they were faced with violence from white supremacists, people that wanted to keep Black people from exercising their newly attained equal rights and citizenship status. So this legal mechanism today that victims of police violence use to seek redress is a direct holdover from the KKK Act of 1871. And the fact that today police use qualified immunity to prevent that liability is so problematic. And qualified immunity was essentially made up, judicially created in 1982, almost 40 years ago. It is not set in stone. It's something that the federal government is well situated to remove as a mechanism to block liability from police departments. Other measures that would help are to lift the secrecy laws that prevent victims of police violence from gaining access to a police officer's record of misconduct. And so again, this is something that both the federal government and local and state governments can do to lift that veil and allow victims of police crime, police misconduct, to look at the history of bad acting and present that information to a jury, present that information to a body that can then actually hold that officer accountable. And what's important to know about reform measures with police departments are very under local control. We have 18,000 different departments in this country. Most of them, by far, are under local, county, municipal control. And so, yes, the federal government can be engaged in changing the laws that regulate police officers, but it's really the local counties, cities, and states that can also impact change. Something else that the federal government can engage in to really transform the way that policing operates in this country is to remove power and control of law enforcement from police back into the hands of the community. And community members are best situated to know how to keep themselves safe, not necessarily strangers that swoop in with guns. So much of policing today, the culture of policing, is to be at war with local communities. And police officers should be in a position to keep people safe. And when we look at what are the safest communities in this country, they're not the communities that have the greatest number of police officers. No, they're the communities that have the best resources, that have safe housing, robust activities for children to be engaged in, quality mental health care services. Those are the safest communities, not communities that are over-policed. So much of the way that law enforcement operates today is a direct holdover from slavery. The very first police patrols were essentially slave patrols. So there were private citizens deputized to monitor, control, capture, re-enslave Black people. And the other arm of policing, very early policing, were privately funded by large corporations to monitor, control, and check this sort of underclass of laborers. And so today, looking at the way that police operate, it's to monitor and control Black and brown people and poor people. The institution of law enforcement is relatively young. The first municipal law enforcement department was founded in 1838 in Boston. And so when we hear defund, abolish police, that's not that radical a concept when we look at the age of the institution of policing. It's less than 200 years old. And then when we think about the abolition of slavery, that is an institution that approximately 240, 250 years old. And so this idea of abolishing the police, when looked at relative to abolishing another institution, it's not that radical a change. And I am heartened with my work at Columbia, the law students, with students at the college, because they come to school, they come to Columbia as self-identified abolitionists. And I think about my own trajectory as a student, as an activist. 15 years ago when I started law school, the idea of defund, abolish the police was not a centrally held, discussed view. I saw myself as entering public interest law to work within the system. That's changed over time. To see my students today enter school, enter law school as self-identified abolitionists that want to dismantle these power systems, that fills me with hope, because the students at Columbia are the ones that are going to be the leaders 10 or more years from now. They're going to be the ones enacting federal legislation. They're the ones that are going to be in positions to look at the way policing happens and actually be able to impart change. And so I'm hopeful, and to see the numbers of people and to see young people engaged in these mass demonstrations tells me that we are experiencing now a systemic shift in the way that law enforcement is policing communities, policing Black bodies. There is a demand, an urgent, a loud, vocal demand for transformational change, for a radical reimagination of the way that law enforcement operates in this country, and a demand for the government, for the people to recognize that Black lives matter. This country has an unfulfilled promise to Black people. The 14th Amendment was intended to provide equal protection of the laws. Redress for Black victims of crime was a primary reason the 14th Amendment was passed. And the fact that we do not have that actualized yet today means that there needs to be, must be, transformational change. And I'm confident that we are now headed in that direction.